I don't make the law, I enforce the law, and I have to apply the facts of every situation to the law as the legislature has passed it and as the governor has signed bills enacting it. And the law in the state of Florida today is that people have a right to stand their ground and have a right to defend themselves when they believe that they are in harm. So we'll talk more about that. But that's against the backdrop that this situation has to be evaluated and has to be considered. So at about 3:30 yesterday afternoon, the Pinellas County Sheriff's Office responded to the Circle A convenience store at 1201 Sunset Point Road in Clearwater. And what we know from the investigation is that Marquise McLaughlin, who's a 28-year-old African-American male, had arrived at the store with his girlfriend, Brittany Jacobs. Brittany parked their car in a handicapped spot by the store. Marquise and his son, who's 5 years old, went into the store. Another person by the name of Michael Draca, who's 47 years old, white male, arrived at the store. He lives in the area and was a frequent customer of the store. And somebody who others have said complained about people parking in the handicapped spots. And he had an issue with people who illegally parked in handicapped spots at that store. So apparently Draca gets out of his car and is checking around Jacob's car and looking for handicap decals or permits or anything that would authorize them to park where they did. When he didn't see that, he confronted Jacobs, and by all accounts is that they got into a pretty significant yelling match. And there was no physical violence, there was no threats, but it was a disturbance, and that they were yelling at each other, and he was complaining about her parking in the handicapped spot. There was another customer there at the store, and the customer went inside and told a store employee that there was a disturbance in the parking lot and that he should do something about it, which was interpreted to mean probably call the police. At that point, Marquise McLaughlin was in the store and learned of the disturbance in the parking lot. And it appears that he learned that it was his girlfriend, Brittany Jacobs, who was involved in this verbal altercation with Draca. So he exits the store, and when he exits the store, and it is captured on video, and we'll show you the video here in a second, he walks out the door and walks straight toward, meaning Draca, walks straight toward McLaughlin. And by all witness accounts, there was no verbalization, there were no statements that were exchanged between McLaughlin and Draca. Let the video pretty much speak for itself, but I'll characterize it this way is that McLaughlin approached Draca. He didn't waste any time getting to him, and then he pushed him, but it isn't just a push, he really slammed him to the ground is what it is. And he pushed him with great force. I mean, this was a violent push. This wasn't a shove. This wasn't just a tap. It was with his hands, and he slammed him to the ground. So Draca falls back, and as Draca falls back, he is on his rear end on the ground. And at that point, McLaughlin is still a few feet away. McLaughlin is facing Draca, and Draca is on the ground. And when Draca had been slammed to the ground, he then reaches, because he's a concealed carry permit holder, and he can lawfully carry a concealed firearm, he reaches and takes out his firearm. And at that point, McLaughlin is still, again, a few feet away. He's facing Draca. Looks like he's starting to turn a little bit, maybe as we would call blading, which is kind of at an angle, but he's not turned away. He's still facing him. And at that point, Draca fires one round from the gun, and it strikes McLaughlin right here in the chest. McLaughlin then grabs his chest and retreats back into the store, where he collapses. EMS responded. He was taken to Morton Plant Hospital, where he was pronounced dead. Draka, after he shot McGlockton, took his firearm, put it in his car, and waited for law enforcement to respond. Draka was cooperative, and during the interview, what he claimed is that he had a verbal altercation, he was approached, he was slammed to the ground, and that he was in fear. And he felt, after being slammed to the ground, that the next thing was that he was going to be further attacked by McGlockton, and that he was focused on McGlockton's lower body, really couldn't see his hands, but he felt that the next thing was that he was going to be slammed again and going to be struck again, and that he was in fear. So why don't we just, it's very short, play the video for you, and then then I'll continue on. So why don't we go ahead and do that?
But for video, TV purposes, how much are you showing?
I'm going to show you the whole thing. I mean, it's short. I mean, it's not even 15, probably 15, 20 seconds, maybe tops. It's short.
Up to the part where he's shot?
Oh, you're going to see it shot. You're going to see him shot.
Yeah, we don't want to show that.
Okay, well, there's no way to do it other than to, you really can't see. You can see him clutch his chest. But that's about all you can, see. I mean, you're not going to see the, there's no blood or anything. You guys can edit out what you want. That's the car pulling in over there. Okay, so this is a little longer version.
Can you give me a warning right before it actually happens?
Yeah,
Yeah, just so we can pull away.
sure. So that's Draka approaching Jacobs. And you can see he's looking around the car. And he's looking for the handicap permit decal. Okay, so this is McGlockton coming out. So he's getting ready to push him, and then the shot's going to be fired. And right here. Okay, so that's the video. So if you count it, between the time the Draka goes to the ground and the time he shoots, it's a count of 4 seconds. It's a count of 4, no more than 5. It's a very short amount of time. And what he claims, and you can tell, it's a violent push to the ground. This isn't just a shove. I mean, he slammed him to the ground. And he said when he's on the ground, because he's in fear, that the next thing that's going to happen is he's going to be reattacked by McLaughlin, and he felt that he was at peril and that he needed to shoot to defend himself. McLaughlin was still standing there. He was still in front of him. He had the ability, the capability to do again or worse what he had already done by pushing him to the ground. As I said, there's no verbalization between either McLaughlin or by Draka during this. And the law on stand your ground is clear, and the Florida legislature has spoken on this. And the Florida legislature has created a standard that is a largely subjective standard. This is not an objective, what I would do, what you would do, what the public would do, what somebody else would do. This is more of a subjective standard, and the person's subjective determination of the circumstance they were in, the fear that they had, is relevant to the determination of whether they're justified in the use of force. So under these circumstances, where you have somebody that is unprovoked, slammed to the ground like that, and his statement that he believed that McLaughlin was going to come back at him, and he fired in a very short amount of time, a few seconds, 4 seconds probably, somewhere in that range. That is within the bookends of stand your ground, and within the bookends of force being justified. And the immunity that people are granted under the stand your ground law is just not an immunity from being charged, not just an immunity from being convicted, but it is an immunity from arrest. And I'm going to read this to you, and this is Florida Statute 776.032, and here's what it says under paragraph 2. A law enforcement agency may use standard procedures for investigating the use or threatened use of force as described in subsection 1, but the agency may not arrest the person for using or threatening to use force unless it determines there is probable cause that the force that was used or threatened was unlawful. So we're precluded from making an arrest in this type of a situation. Then it goes on to say that the court shall award a reasonable attorney's fees, court costs, compensation for loss of income, and all expenses incurred by the defendant in defense of any civil action brought by the plaintiff if the court finds that the defendant was immune from prosecution. So, one, we got to follow the law. Two, if we don't follow the law, we're civilly liable for not following the requirements of Florida stand your ground law. Importantly, the legislature this session changed the framework for stand your ground. The framework for stand your ground used to be that the defendant had to raise stand your ground as a defense, and the defendant had the burden of proving that they were entitled to immunity under stand your ground. And the legislature changed the law, and the law now is that the state attorney has the burden of proof by clear and convincing evidence that the defendant, the shooter, is not entitled to stand your ground. Nowhere else is there anything like this in criminal law where that somebody asserts something and the burden then proves to the other person or shifts to the other person. So the law is changed dramatically because you've got a situation here where stand your ground allows for a subjective belief by the person that they are in harm's way, they're in fear. In this case, this guy was slammed to the ground. In very short order, he felt it necessary, seconds, felt it necessary to defend himself because he felt he was going to be attacked again. And in order for him not to be justified, you have to take it outside of those bookends, and we are precluded from making an arrest unless we have probable cause that the person committed a crime, and we don't have probable cause here of that. And even if we were to charge, or if the state attorney were to charge, All he has to do is say, stand your ground, and then the state attorney has the burden of proof by clear and convincing evidence at a stand your ground hearing that he is not entitled to stand your ground immunity. And that's a very heavy standard, and it puts the burden on the state. So under these circumstances is that we cannot make an arrest. We're going to refer this to the state attorney's office. The state attorney's office will review it and apply the law to the facts and make a determination as to whether something should be charged. You know, before stand your ground, a case like this probably would have a different outcome. You know, as you can see in there, there is a pause, even if it's only for a couple seconds. There is a pause between the time Drake hits the ground and he shoots. That pause gives me pause. That pause gives me some concern, and it goes back to what I said when I opened. Just because you can doesn't mean you should. But I don't get to, and we don't get to, substitute our judgment for Drake's judgment. My question is, and what I have to do is make a determination, applying the law to the facts. Is he within the framework of what the law allowed him to do? Does this law create a situation potentially where people shoot first and ask questions later? Well, you can have that discussion. You can have that debate. I don't make the law. We enforce the law, and I'm going to enforce it the way it's written, the way the legislature's intended for it to be applied, and others can have the debate about whether they like it or not. So this will go to the state attorney. Draco will not be charged. He will not be arrested by us because we're precluded from effecting an arrest. The state attorney will view it, and either he'll concur or not. And if he concurs, then there'll be no charge, period. If he doesn't concur, then he'll make a determination as to what to do with it. And if he feels like that he can overcome that heavy burden at a stand your ground hearing of proving by clear and convincing evidence that Draco was not entitled to use force in this circumstance, then that's the state attorney's determination to make. So, I just ask everybody to understand, and there are a whole bunch of people I know and I've already got emails about it, and people are already starting to voice concern over this. And I understand that. I don't make the law, but I will enforce the law, and I'll enforce it fairly as the legislature has directed that it be enforced. And under these circumstances, this fits within the framework that the Florida legislature has crafted for all of us to live by in the state. So, and I'll take any questions that you have.
So you talked about that pause when he pushed him to the ground. There you counted 4 seconds, Sheriff, but he's not coming after him during that pause.
Doesn't matter.
Show any more aggression. Can you kind of go?
Doesn't matter, because this guy's on the ground, and you know, no matter how you slice it or dice it, that was a violent push to the ground. That was a slam to the ground. So he pushed him to the ground. He violently goes back on the ground. Then he's sitting there. He takes the gun out, and what he's seeing and what he's saying in his mind is the next thing he's thinking is, this guy's going to come at me again, and he fires. And is that within the bookends of a reasonable belief by his part, on his part, under those circumstances of that time? Yeah, it's within the bookends. Now, you could say, is it on the fringe of the bookends? I don't know. I'll leave that to others to judge. But is it within the bookends? Is he legitimately, could he be in fear after that violent slam to the ground? Could he be in fear that the next thing is this guy's coming at him again when the guy's standing right there and he's standing right there like this? Yes, he could. And, you know, could he have said, hold him at gunpoint? And you could cut that both ways. He could hold him at gunpoint and not fire. Yeah, he probably could have done that. But also, the fact that he's holding him at gunpoint could also cut towards his legitimate fear. And that, you know, the guy didn't turn around and run away real fast. And the guy didn't do anything. He said, hey, man, don't, you know, we're good or something. He didn't do any of that. So it cuts towards this guy's belief in his mind that he's going to be harmed again, and he had to shoot to defend himself. You know, and those are the facts, and that's the law.
But there were no direct words between the two men that you know of.
They didn't know. And I'm not going to get into altering the facts, because altering the facts alters the outcome. But if you were to engage in that exercise, and you were to alter the facts further to the left or further to the right, and you were to change this scenario, it could have a different outcome. And if there were an exchange of information, and if the exchange of information was Marquise McGlockton making threats to him, verbalizing and saying things that buttressed his belief that he was in harm, in imminent harm, then that cuts more towards justifying the shooting. If Marquise McGlockton was saying stuff like, hey man, we're good, and you know, forget about all this, then it cuts the other way. If you have longer time, like 8 or 10 or 15 or 20 or seconds, and McGlockton had turned away, well then that changes the outcome. But we can't change the outcome, we cannot change the facts. The facts is that he approached him, slammed him to the ground, and within about a 4 count, he fired. And no words were exchanged. We've got to use only the facts, and the facts are clear based upon video and eyewitness accounts.
Speaking to the owner of the store, he tells us that the man who fired the shots is a nuisance there, that he's caused problems in the past with other people. Do you know, are you familiar with this person? Have you been called there to deal with problems that he started in the past?
Yeah, I'm not aware, Holly, that we have been called there to deal with him in the past. There have been some incidents in the past, and we're aware of those incidents. But what's material here is what happened at that instant. You know, we have to recognize that if Marquise McGlockton hadn't walked up to him the way he did and slammed him on the ground, we wouldn't be here having this discussion either. So what's relevant is not whether this guy's a good guy, nice guy, or whether he's a jerk, or whether he's a thorn in people's sides, and what he's done, whether it's 3 weeks ago, 3 months ago, or 3 years ago. What's relevant, and the only thing that we can look at here, is was he in fear of further bodily harm because of what Marquise McGlockton did, and was he in an ability and have the capability to carry it out? And the answer is yes. So that's what we got to look at. And I'm not saying that this guy, he might well be a thorn in people's side. He might be a jerk. He might be all of those things. That doesn't matter. That doesn't matter. What matters is, did McGlockton slam him to the ground? Yeah, he did. And was this guy put on his rear end? And was McGlockton standing over him and in a position to do what he thinks McGlockton was getting ready to do, which was to come at him again and harm him further? Yes. And does Florida law allow you to defend yourself and stand your ground? It does. That's what the Florida legislature has said. And so, you know, our job and our role is not to substitute our judgment for the law and what the legislature has crafted as a framework, but to enforce it equally and fairly as we're required to do. I'm not saying I agree with it, but I don't make that call.
Do you disagree with it? Would you come out and say you disagree with it?
Well, I'll say this, is that I am a firm believer in the adage that just because you can doesn't mean you should. But I'll also say this, is I'm not going to substitute my judgment for Drake's judgment sitting on that ground after having been slammed to the ground either. And, you know, and from his perspective, sitting there on the ground, and within a few seconds, literally, because he took the gun out and he made a decision. So it really doesn't matter what I would have done or what anybody else would have done. You know, and you know, would I have done something different? You know, there's a difference between, you know, arguably too, what a what a law enforcement officer would do. And this guy's not. He's just a citizen. And he felt he had to defend himself.
Sheriff, where does the law come into play where he's running out thinking that his family is being threatened and he feels like he has to defend his family?
There's no evidence of that. And again, you know, that's what you got to be real careful with. You can't, you know, and I get the tendency, but you can't impute facts that don't exist. And there is no evidence, no testimony, no witness accounts that his family was in harm's way at all. It was purely verbal. purely verbal. And by all accounts, there's not even any threats. They're just arguing back and forth about the handicap spot. You know, and I'm guessing, but we can't unfortunately talk to Marquise because he's deceased, is what was going through his mind. He probably didn't like the fact, and I don't think it takes a giant leap to get there. He didn't like the fact the way this guy was talking to his girlfriend. But also, you know, Marquise shouldn't have gone up and slammed him to the ground either. You know, he should have said, look, man, knock it off. You know, he didn't have a right. You know, Marquise engaged in unlawful conduct himself. Marquise should not have gone up and slammed this guy to the ground. You know, and Marquise wouldn't be dead if Marquise didn't slam this guy to the ground. So, you know, Marquise has got skin in this game too. And the reason why it makes it justified and within the framework of stand your ground is because of what Marquise did. It's sad. It's really sad. You know, and again, we can have a discussion about, you know, what we would have done or what the law would be, or what we would have done under the law prior to stand your ground, or prior to even the change that puts the burden on the state and makes it a clear and convincing evidence standard. We can have those hypothetical discussions all day long, but I don't live in a hypothetical world. I live in a world of what's the law, what are the facts, and how are we going to apply it as directed, and that's what we have to do.
But are you frustrated with, especially this change now that puts the burden of proof on the state attorney? Can you tell us if that frustrates you and your job?
You know, it's a mixed bag, I'd say. You know, I mean, there are times, I mean, you know, look, you know, people should be able to defend themselves. They should. There are times, and I can give you, again, we can come up with situations and scenarios where I do believe that stand your ground has its place. And I think that it can be something that is properly used. You know, so as an example, you know, before stand your ground, if somebody's walking in the mall parking lot and somebody comes up and attacks them, is that they're required to make an effort at least, or reasonably retreat before they can use force. You know, I don't think if somebody comes up to you in the mall parking lot and tries to rob you, that before you can use force and defend yourself, that you should be required, there should be a requirement in the law to retreat first. You know, then you get the other end of the spectrum, which, you know, somebody can certainly make the case that maybe this guy could have handled this differently. But, so that's why you got a range, and you got bookends. And you're going to have things that fall toward one end of the bookend or the other that aren't squarely in the middle. And I think there's an argument this probably falls towards maybe one end of the bookend, but it doesn't take it outside the bookend. And it doesn't mean that you throw the baby out with the bathwater. And I see where there can be benefit and the right thing for people to be able to protect themselves. You know, look, nobody has a right to harm somebody else. Nobody has a right to commit a crime against somebody else. And no matter how you slice it, dice it, or otherwise, you got to come back to is that Marquise McLaughlin wouldn't be dead unless Marquise McLaughlin slammed this guy to the ground. And, you know, don't put your hands on people. Don't slam them to the ground. And if you do, you're taking a chance that that person might be a concealed carry permit holder, and they may decide that they're in fear and they're going to defend themselves. Well, that's not, you know, that's the world we live in. So don't slam people to the ground. You know, and, you know, people have a right to do that, to defend themselves.
How long you may not know this question, but how long do you think the state attorney's office is going to have this investigation?
I have no way of knowing that. I can't comment on that. You know, I mean, it'll take us a few days to package it all up and to do all the reports and to get everything together and then submit it to them. And then the state attorney will conduct his own investigation and evaluate it. But I can tell you that it's not going to be short order. I mean, if that's what you're asking, are we talking, you know, hours or days? Or are we talking weeks or months? Well, it's not hours or days, and that'll be up to the state attorney to make that determination. But I think it'll take them some time to evaluate it.